We need a simple divorce. I'm Diana Martinez, and a big part of my law practice is in divorce and dissolution. Every now and then I get this request, or a couple comes in and says, this is going to be the easiest divorce you've ever done. The reality is that very few divorces are truly that simple. So I'm going to break it down for you, starting with the simplest divorce and then highlighting where people often struggle and how to get through it more smoothly. This information is specific to California only, and it is general in nature. I'm not your lawyer. This video does not create an attorney-client relationship, and this information is not specific to your case. You should consult with an attorney before taking any action relying on this information. So here's your simple divorce. It's called a summary dissolution, and you can absolutely do this on your own, but there are strict requirements and you have to meet each one. So aside from meeting the requirements to be able to file in California, if you have been married or in your domestic partnership less than 5 years, that's date of marriage to date of separation, and have no minor children from the relationship and neither of you are pregnant, and neither of you has any interest in real property other than a lease where you live that terminates within a year of filing the dissolution and does not include an option to purchase, and owe no more than $6,000 in debts, not including car loans that were incurred during your marriage or domestic partnership, either individually or together, and you hold less than $41,000 in community assets, again, not including your cars and not including what you owe, and neither of you has separate property assets of more than $41,000, again, not including what you owe on the assets or on the cars, then you qualify for a summary dissolution. Go to the courthouse, get the forms, go ahead and file. You have to file together, okay? So if you don't qualify for summary dissolution, and most people do, I've done a grand total of 3 in the 25 years I've been in practice, there are things you can do to simplify your divorce or dissolution process. First, you need to manage the emotions and the communication. And this is an area that people just completely ignore. It is hard to talk about money with someone you don't trust or that you're angry with. If communication was difficult before you started the dissolution process, it's not going to get easier after. This is where you want to work with a therapist who is trained in divorce mediation or collaborative divorce. Their sole goal is to help you both focus and communicate so that you can resolve. Think about who you are or who your partner is. If they are conflict averse, they shut down or they say yes just to avoid the conflict and then later change their mind, your divorce will not be simple. You're going to need help here. And this is an area a lot of people just ignore. Number 2, hand in hand with emotions and communication, is your behavior and your language. It matters. You have habits on how you deal with each other that you have perfected over the years, so much so that it's like breathing. You don't even have to think about it. Odds are the habits won't help you get to a resolution. Words like you always or my kids instead of our kids create more conflict. And if you're already in a new relationship, that makes it even more difficult. Social media has taken divorce conflict to a new level. From a real life perspective, your soon-to-be ex is less likely to be cooperative after seeing pictures of you traveling with your new partner. Even if your ex isn't on social media, those posts find a way of getting in front of them. And from a legal perspective, a lot of those posts end up in front of a judge, which can be a problem if your friends are posting pictures of you enjoying a week at a posh Hawaiian resort when you're claiming you have no income for child support. Look, you have every right to a personal life. And the reality is that during your divorce, everything you say and do will either get you closer to where you want to be or take you further away. So to the extent that you can, shut down your social media and ask others not to post anything about you. Just keep your private life private. Third, you both need to understand your finances. You're going from one household to 2, and that takes planning, which requires understanding what you have now, what's possible in the short term, and what you'll need moving forward to get you where you want to be. $50,000 in a retirement account is not the same as $50,000 equity in a house. If your spouse or partner doesn't understand the finances, they won't appreciate how good your proposal is. And sometimes that's just because it comes from you. This is where a neutral financial can really streamline the process by creating a safe way of sharing accurate information so that you can both confidently say yes. Number 4, cooperation is key. The smoothest divorces are those where the couple considered each other's concerns when exploring solutions. Sometimes it's only on one issue. Maybe you only agree on the children. Find out why you agree only on the children. What are the underlying principles and values that you bring? How are you both communicating when you're talking about the children? If you give each other a sense of support rather than competition, you'll have a much easier time resolving. I work with family specialists and divorce coaches who are not only experienced therapists and child specialists, but they know the court system and how to help couples stay in control of themselves to streamline the family transition. Finally, let's say you've reached agreements on everything. The forms are confusing and have serious legal consequences sometimes those can't be corrected. And there is no form for the agreements themselves. Some people will work with a paralegal or they use an online document preparation service. I don't recommend either. There are some really great paralegals out there. The problem is that you may not know that a mistake was made until it's too late. And you may have no recourse because paralegals aren't licensed by the bar. Case in point, a gentleman came to my office and told me he needed to be divorced before the weekend. That's not going to happen. Turns out 2 years before coming to me, he had worked with a paralegal to do his divorce. The judgment was rejected because of an error and he was never notified. He had had no contact with his ex, had no idea how to find him, and only learned of the situation when he tried to get his marriage license for his new wedding. And he was told that he was still married. In order for me to be able to get his judgment corrected and get him divorced, I had to give notice to his ex. And since we didn't know where his ex was, that had to be done by publication over several weeks. Then you have to show the court that you've complied with that step and then wait for the court to approve. Needless to say, he wasn't very happy. When it comes to online services, they often use a find and replace feature in a boilerplate draft judgment. The clerks in the court really don't like these because oftentimes they're not properly updated for new changes in law, or they're missing local information that's required by the local rules. So what happens is the clerks will reject the judgment and send it back to the parties. Well, if the parties are no longer at the address that was included in the forms, they're never going to get the notice, which causes a backlog, and that's something that frequently happens. Your best bet is to find a family law attorney who is trained as a mediator or a collaborative lawyer who can make sure that you have all of the necessary information to get the judgment through your specific court. There are lawyers who will not review a judgment that they didn't prepare, and the reason is there's a lot of liability involved in that. Some will do it. You also have the option of going through a court's self-help center. They can work with you, but they cannot give you legal advice. And how to fill out a form, a legal form, is giving legal advice based on what the state bar has ruled. And again, there's no form for your agreements. So after hearing this, even if your situation isn't as simple as you originally thought, there's a lot you can do to streamline the process. Working with the right professionals is a big part of that. If your goal is to focus on what's important to you and to make sure you have an agreement that makes sense and is binding, I strongly recommend an out-of-court process like mediation or collaborative divorce. If you're not sure which would be better, let's get you scheduled for a strategic process planning meeting where we'll go through your circumstances and figure out how to streamline your process together.